Make sure you got cell phones or silent or off.
Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what is called an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offense. It does not mean that they're not serious, just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. Now, if a person is convicted of a third degree felony, the range of punishment is minimum 2 years to maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those type punishments. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way down to the bottom. We have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is by a fine only, cannot be given jail time. It's a fine only, and the fine cannot exceed $500. Now, Class C misdemeanors are cases that come to this court from the city court or the Justice of the Peace Court, which is the JP court. They come to this court when a person is found or is convicted in the city court or the JP court, and then they appeal the case. In essence, they want a new trial. And so they get a new trial. We call it a trial de novo. And the range of punishment does not change. It's still the same, which means that it is a fine that does not exceed $500. Now, I'll just give you an example of a Class C misdemeanor. Speeding is a Class C misdemeanor. Not having a seatbelt on is a Class C misdemeanor. Or maybe you had an expired license tag. That's a Class C misdemeanor. Those cases and other Class C misdemeanors only come to this court when a person is found guilty or convicted in the JP court or the city court, and then they appeal their case. All right. Now, the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. With the Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such jail time and a fine. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Sometimes we refer to it as deferred adjudicated probation. With that type of probation, you don't have a conviction on your record. And if it's such a completed, the case will be dismissed, and you will qualify for a non-disclosure where your record is sealed to the general public. Okay, that's unadjudicated probation. The other type of probation is called adjudicated probation, and with the adjudicated probation, it does result in a conviction on your record. However, there's something that is called judicial clemency, which means that the judge can set your conviction aside and you will no longer have a conviction. Now, in order to qualify for judicial clemency, three things has to happen. Number one, you have to successfully complete probation. Number two, there cannot be any more time left on the probation. And number three, you have to be discharged or let off the probation by the probation department. If those three things happen, then you qualify for judicial clemency, and the court has the discretion to set your conviction aside, which means you will no longer have a conviction. Now, however, if you get a subsequent conviction, meaning that if you get another conviction later on, then the case that you received judicial clemency on can be brought back up. It could be revived, or it could be resurrected, and it could be used against you. And if you try to get a license with Child Protective Services, they can deny giving your license, or if you have a license, they can suspend or revoke that license. Okay, now everyone here should have a clipboard. Who does not have a clipboard? You have a clipboard, okay? And I'm going to go over that information with you that's on the clipboard. Now, the first page on the clipboard should be titled Judge's Explanation of Rights to Defendants Without Attorney. The document looks like this, okay? The document looks like this. This is the judge's explanation of rights to defendants without attorney. I will constantly refer back and forth to this document. So the documents, the first sentence states that as a defendant in a criminal case, you have three options, and they list the three options. You have three options. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Okay. So the first sentence under number one states that if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. Reset means that you'll be given another court date. So to give you time to hire your attorney. Now, the next paragraph, one sentence paragraph, states that if you want an attorney, but you do not have enough money to hire an attorney, you may request or ask the court to appoint an attorney to represent you. But you must first sign a financial questionnaire. Now, this is only for individuals who will be requesting a court-appointed attorney. If you will not be requesting a court-appointed attorney, you do not have to listen to what I'm getting ready to say. Okay, so if you are requesting a court-appointed attorney, you have to fill out a document that is titled Jefferson County Affidavit of Indians. It is a 3-page document that is also on the clipboard, and it looks like this. Okay, it looks like this. Now, this is only for individuals who will be requesting a court-appointed attorney. Now, you would have to fill out the entire first page. You answer the questions on the first page. And then you go to the second page. And on the second page at the top, it states Defendant's Oath. You would have to fill out this section that is titled Defendant's Oath. And then the middle portion that's titled Unsworn Declaration by Defendant and then you'll stop. Okay, this is only for people who will be applying for court-appointed attorney. Now, referring back to the first document, judge's explanation of rights to defendants without attorney, you notice that number 3 states that you may represent yourself. Now, what that means is you'll be waiving or giving up the right to have an attorney, you'll be representing yourself. That is, you'll be acting as your own attorney. And just like an attorney can talk to the assistant criminal district attorneys who's in court to see whether or not you can work out or enter into or agree to a plea bargain. A plea bargain is where it's a settlement on your case. You agree to settle your case, okay, for an agreed punishment. Now, just like the attorney can do that, because you're representing yourself, you will have the same option because you are your own attorney. And so you can talk to the district attorney's office to see if you would like to, settle your case, see what they're talking about, because you're your own attorney. Now, on this document, the third one-sentence paragraph states that you may not speak to the prosecutor's assistant criminal district attorney, unless you first sign a waiver of your right to be represented by an attorney. Now, this is only for people who will be representing themselves. The waiver is also on the clipboard, and this is only for people who will be representing themselves. The waiver looks like this here. It's a document that's titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You have to read and fill out and sign your name on the line that's titled defendant, and you dated today's date, July 28th. Now, going back to this document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial, it states, for individuals who like to represent themselves, there's a paragraph in block form at the bottom. It states that be aware that the dangers and disadvantages of self-representation, waiving your right to an attorney and representing yourself may result in the worst outcome for you in your case, including the loss of significant rights and opportunities related to military service, possession of firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you are representing yourself, this last one-sentence paragraph states that you may change your mind at any time and request that an attorney be appointed to represent you, or you can hire your own attorney. Now, what that means is this. Let's say you're representing yourself and you're interested in talking to the prosecutor to see if you can work out a settlement on your case, and you have in mind that, well, maybe I will see if the prosecutor will give me a fine only. Okay. And then you talk to the prosecutor, and the prosecutor say, no, we're not going to offer you a fine only, and offer you, let's say, probation, jail time, whatever the offer is. And you say, well, I don't want that offer. You can change your mind and ask for an attorney to represent you. Okay? So you can change your mind at any time. Okay, now at the bottom of this document in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, you'll place your initials on the first line to the left. Now everybody here is going to make a choice. If you've already hired an attorney to represent you, place your initials on the second line to the left and the name of the attorney on the line to the right. If you like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. And then you would have to fill out and sign this document that's titled Jefferson County Affidavit of Indigence. Now, the fourth line states that if you have already been appointed a court-appointed attorney, Then you'll place your initials on the line to the left and the name of the attorney on the line to the right. And the last line states that if you would like to waive your right to an attorney, that is to represent yourself, you place your initials on the fifth line to the left at the bottom, and then you'll fill out and sign this document that is titled waiver of counsel for purposes of entering guilty plea or proceeding to trial. And then once you finish initialing one of the 5 lines to the left, you'll sign your name at the bottom of this document where it says defendant, and you'll place today's date, July 28, 2026. And just as a brief recap, if you are requesting time to hire your own attorney, this is the only form you would have to sign. You don't have to worry about anything else. Or if you have an attorney representing you already, once you place your initials on the second line to the left, the name of the attorney, this is the only form that you have to sign. If you are asking for a court-appointed attorney, put your initials on the third line, sign and date this form, and then you will fill out the first 2 pages of Delaware County Affidavit of Indigence. Or if you've already been appointed a court-appointed attorney, you'll place your initials on the fourth line to the left, the name of the attorney on the line to the right, and this is the only form that you would have to sign. If you're asking for, if you would like to represent yourself, then you'll place your initials on the fifth line to the left, and then you'll fill out the form that is titled waiver of counsel for purposes of entering guilty plea or proceeding to trial. Do we have any questions? Anybody? Yes.
Say I have a different case with a different judge and they appointment. Does that still go?
No, that lawyer in that other court is not assigned in this court. So you would have to request a court-appointed attorney in this court.
You said time to buy.
You can change, now, if you represent yourself,
Take myself out.
you can change your mind at any time. Okay? Anybody else have any questions? Okay. Oh, yes.
You're not accepting that a guilty plea and once you represent yourself. How is that?
Okay, if you would like to represent yourself, but you're entering a plea of not guilty. Okay, we call that pro se, then you're representing yourself. And then one, you'll have an opportunity to talk to the prosecutors. If you don't agree with what, well, if they make an offer, you can accept or reject the offer, you reject the offer. Then at some point, you still want to represent yourself, then you'll have access to the evidence that the state has, because in essence, at that point, you're preparing to go to trial against the state. So that's, we call that pro se, you represent yourself. Okay, anybody else have any questions? Yeah, we'll get somebody, he speaks Spanish? Okay, we'll have an interpreter coming in here to help. Okay, anybody else? Okay, now, what I'm going to do is, we're gonna give you time to fill out that paperwork. And so I need to go over some more rights that you have. One other right that you have, you have a right to have a trial, but you're pointing over here to the area, we call that the jury box, where you see 12 chairs. 6 citizens of Jefferson County will be selected as jurors to serve as jurors in your case if you decide to go to trial. Now, before we go any further, you have the option to enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting the charges that they have filed against you. Okay? Now, as I mentioned to you earlier, that area is called the jury box. 6 citizens from Jackson County will be selected as jurors to serve as jurors in your case. They will listen to all of the evidence of the state, all of the evidence of the defense. They will listen to the arguments of the state and the arguments of the defense, and then they will go back into the jury room, which is behind those doors. And they could, then once they deliberate, they can either find you not guilty or guilty. Now, you also have a right to waive or give up the right to have a jury trial. But what that means is you will not be having a jury trial. You're waiving or giving it up. However, you still can have a trial. You can have what is called a bench trial. A bench trial is a trial by judge. The judge will be the judge and the jury in the case. And the reason why they call it a bench trial is because the judge sits on the bench. And so the judge will listen to all of the evidence of the state, all the evidence of the defense, listen to the arguments of the state, listen to the arguments of the defense. And then the judge will apply the facts of the law and decide to find you either not guilty or guilty. Okay. Now, if you enter a plea of guilty or no contest, then that means that you would like to work out a plea bargain agreement with the state. And so if you're representing yourself, you'll talk to the prosecutors. If you have a lawyer, your lawyer will talk to the prosecutors. Now, if you or your attorney have talked to the prosecutors and you do not agree, in essence, you do not accept the plea bargain agreement, or put it like this here, let's say you come to an agreement. You wanted a fine, they offered a fine, and you have an agreement. Then what happens is the case, that agreement goes before the judge. The judge can do one of two things. The judge could either accept or reject your plea bargain agreement. If the judge rejects your plea bargain agreement, then the law says that you can withdraw your plea. In essence, you can take back your plea. In essence, you can say, well, judge, since you're not accepting the plea bargain agreement that I made with the state, I withdraw or I take back my plea. In essence, I'm not pleading guilty or no contest. All right. Now, if the judge follows the plea bargain agreement, or meaning that the judge accepts the plea bargain agreement, and let's say within 30 days of the plea agreement, you decide that, you know what, I think I've been wrongfully convicted, or the court has committed an error by convicting me. And so you would like to appeal your case. You have to get permission from the judge that followed the plea bargain agreement to appeal your case. And if the judge gives you that permission, then your case is going to leave this court. It's going to go to the Ninth Court of Appeals, which is located right above us on the 3rd floor. There are 4 justices up there, 4 judges up there. They will review your case. And they will if they can do one or two things. They can accept or reject your appeal. If they accept your appeal, they can simply find you not guilty. And, case is over. Or if they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas. And the highest criminal court of the state of Texas is the Texas Court of Criminal Appeals. Now, you would have to file what is called a pro se petition for discretionary review. Pro se means you represent yourself and you are petitioning the Texas Court of Criminal Appeals to review your case. Now, they can do one of two things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. Case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders to give you a whole new trial. Now, if they reject your petition, okay, from say you represent yourself and you're asking them to review your case to see if they should have granted your appeal, or this case, this court committed an error by convicting you. If they reject your petition, then at that point, your conviction will stand. Okay, now, the next right that you have, we talked about, your right to have a jury trial, we talked about your right to have a bench trial, we talked about having the option to enter a plea, come to a plea bargain agreement. Now, let's say you in the state does not come to a plea bargain agreement. You wanted a fine, they are offered jail time. And you say, well, I don't want the jail time, but I still want to plead guilty and no contest, so I want the judge to decide. That's called an unagreed plea bargain. And that's, you don't have agreement with them, it's unagreed. And so now it goes before, you want the judge to assess the punishment. And so the judge will assess the punishment anywhere within the punishment range. For a class, whatever you charge it, if it's class A, class B, or class C. Okay. Now, the other right that you have a right to have witnesses to come to trial, and witnesses can testify for you or against you. And they sit in that chair that has the microphone that's called the witness stand. Now, you also have the right to waive your right to have witnesses, or give up your right to have witnesses. What that means is that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have a right, it's a Fifth Amendment right against self-incrimination. The Fifth Amendment of the United States Constitution gives us a right not to testify in our case, in essence, not to incriminate ourselves. A lot of times we watch television shows like Law and Order, and we may see a television lawyer walk up to the witness stand and ask the witness questions. And the witness says, I take the fifth. What that witness is saying is, I'm exercising my Fifth Amendment right to remain silent. So the state can't call you as a witness if you have exercised your Fifth Amendment right to remain silent. Now, it makes sense, in my opinion, because the reason why I say it makes sense, because the state of Texas has the burden to prove that you're guilty. That it's their job to prove beyond a reasonable doubt that you committed the offense that you have been charged with. It is not your job to prove yourself guilty. Okay? Now, the other thing is, you have a right to have discovery. And what discovery is, you have a right to see what's in the state's file. Okay? That in essence, you have a right to see your statements, witness statements, police reports, lab reports. You have a right to see photos, video recordings, listen to audio recordings, right? They have access to documents, instruments, whatever the state has in the file, you have a right to have access to that evidence. Okay? That's called discovery. I guess the reason why they call it discovery is because you've seen it or you discovered it for the first time. Okay, sir? You have a case?
I do not, Judge. I was coming to speak, but it seems like you are.
Yeah, I'm doing a regular.
Yeah, I see that.
All right,
I'll talk to you, all right?
okay. Yeah,
Okay.
and so, so that's the, you have a right to see or have access to the evidence that the state has against you. Now, you can waive or give up your right to have discovery, which means you're waiving or giving up your right to have access to the file. Okay? Now, everyone that's here today for a case, you have been charged with an offense you've been arrested, uh, placed in the Jefferson County, or placed in a county jail, you bonded out of jail, you're either out of jail or cash bond, which means that you paid the full amount of the bond to get out, or you may be out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail. Or you may be out of jail on what is called a personal recognizance bond or a pure bond, which means that you did not have to pay any money to get out of jail. You was just released under your own personal recognizance. Now, I've said that to say this, every day that you spent in jail can be used as credit towards your punishment. So, the operative word is every day. So let's say you were booked into jail at 11:59 p.m. last night. And then you booked out of jail at 12:01 a.m. this morning, which is 2 minutes later. You get credit for 2 days. The reason why is because 11:59 was Monday, 12:01 was Tuesday, so it's 2 different days, so you get credit for 2 days. All right, so every day that you spent in jail can be used as credit towards your offense. So let's say you spent 5 days in jail, and let's say the state is offering that you serve 5 days in jail. That means you will not have to serve any more time in jail because the 5 days that you spent in jail has already, you'll be given credit for what is called time served. You've already served 5 days. Now, if the state is offering 7 days in jail, that means that you will only have to serve 2 days in jail because you already served 5. And so we subtract 5 from 7, that leaves 2. Now, every day that you spent in jail can also be used as, actually, every day that you spend in jail, you're credited $100 per day that can be used toward your fine and court costs. So for example, if you serve 5 days in jail, that's $500. So if the state is offering you a fine and court costs of $500, that means you won't have to pay anything because why? You already $500, you spent 5 days in jail, that's $500, so it will be taxed in the tax. Now, if they're offering fine and court costs of $700, that simply means that you would have to pay $200 because you already have $500 for the 5 days that you served in jail. Now, you'll be required to pay the $200 on the day that the case is taken care of or disposed of. If you are unable to pay the money on the day that the case is disposed of, then we can put you on what is called a payment plan, which means that you can pay it off in small monthly installments until it's paid off. Now, let's say you do not have the income to pay it off in small monthly installments. Well, it's no problem because we can convert your fine and court costs to community service. And so for every 1 hour community service that you perform at a nonprofit organization in Jefferson County, it could be used, you will be given, that is, credit of $12.50 that will be used toward the payment of your fine and court costs. So for example, if you owe $200, you work 1 8-hour day community service, that's $100. So you work 2 8-hour days, that's $200. Okay? And so your fine and court costs will be paid off. All right. Now, Jefferson County has a program that is called pretrial diversion. If you have not been charged, if you haven't been in trouble before, let's say you haven't had any convictions or probations before, then Jefferson County has a program for a person who is like their first time getting 1 or more cases. Then the program is called pretrial diversion. And with pretrial diversion, what they will do, they will dismiss your case. Once you complete the program, And you can get it expunged from your record. Expunged means erased, deleted, or wiped off your record like it never happened. Now, in order to qualify for pretrial diversion, three things has to happen. One, it has to be your first time getting one or more cases. Two, it cannot be for an offense involving unlawfully carrying a weapon or resisting arrest. And three, you have to have an attorney to assist you with the application process. Now, an attorney does not have to be hired. The attorney can be appointed. All right? Now, if those three things happen, you get into the program, your case gets dismissed, and you can get it expunged, which means erased, deleted, or wiped off from the records. Now, if you're a veteran of any one of the branches of the United States military, Jefferson County DA's office has another program that is called Veterans Court. It's for veterans only. The only requirement to get in the program is to be a veteran. Okay. And once you get into the program and complete the program, they will dismiss the case and you can get that expunged from the record. I think that's that. All right. Now, this court, County Court at Law number 2, Jefferson County, Texas, has a program that is called the Community Safety Initiative. It's commonly referred to as the CSI program. It's a program that God led me to start in March of 2017. With that program, we have partnerships with various agencies in our Southeast Texas region. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop is our mental health center. And what Spindletop can do, they have the expertise to address mental health issues that individuals may have. Now, in order to participate in the program, you do not have to be incompetent or insane. You can just merely suffer from depression, anxiety, or any other host of mental illnesses, and they have the expertise. They have doctors, they have counselors, they have mental health deputies, and various other people employed to address your mental health needs. Now, basically, Spindletop comes to court on Tuesdays, like today, and what they'll do, they can conduct a private interview in our jury room in the back, or they can conduct the interview at their facility or by telephone, by text, or whichever is convenient to you. Spindletop will also be able to do what is called an assessment. An assessment is to determine what your mental health, to diagnose what your mental health issue may be. And they also have the ability to develop a treatment plan to address your mental health issue. If you are unemployed or if you're looking for, if you have issues with alcohol or drugs, then Spindletop also has another program that is called ATAR. It's an acronym that's ATAR, that stands for Addiction Treatment and Recovery. We also have a partnership with our Golden Triangle Empowerment, with our local drug and alcohol council that has a program that is called OZAR. OZAR is an acronym, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both the ATAR and the OZAR program, alcohol and recovery programs, and what they will do, they will do a screening, which is an interview. Then they will do an assessment to determine what your issues with alcohol and drugs are. And then they can develop a treatment plan for either outpatient or inpatient treatment. Also, if you are unemployed or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called OZAR. That's called CICE. Now, CICE is an acronym that stands for Center for Innovation, Commercialization, and entrepreneurship. It is a job training and a job placement program in the hotel industry and the chemical industry. Once you are trained in any one of those areas that you select, then they will help you to get a job in the area that you're trained. If you have not graduated from high school, or if you do not have a GED, well, Spinatop and CICE both have GED programs where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free, does not cost you anything but time. And I like to say in this court, we do not just give time. We take out time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to do. And so I like to say that when you come to County Court at Law number 2, Jefferson County, Texas, we do not have court as usual, we have unusual court. And it's not because we're different, it's just because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their life, it will make a difference in their home. And if we make a difference in their home, we'll make a difference in the community. Because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned, just let us know. And we'll be happy to direct you to the people that you need to talk to about getting on the road to living your best life. Now, the paperwork that you have on the clipboard, as I mentioned to you earlier, we're gonna pick that paperwork up. What I failed to mention is at the top of the document, it states the fitness, it states state of Texas versus, and it has a line blank. Please print your name on that line. And the reason why I say print, because if your handwriting is like mine, sometimes I can't read, so we can print it, so we'll be able to match the document with the person that it belongs to. Okay, now the other thing is we're going to pick up those forms. If you need help with filling out the paperwork, we have our 4 personnel who's here, including myself, who will be happy to assist you with filling out the paperwork. Now, it's gonna take us a little time, a few minutes to pick up the paperwork from you. And once we pick up that paperwork from you, then we're gonna put you into one of 3 categories. One category, you want to hire an attorney. Second category, you would like to see if you qualify for court attorney. And the third category is you will represent yourself. Now, if you are requesting time to hire your own attorney, your case will be reset today. And to give you time to hire an attorney. Or if you are requesting a court-appointed attorney, if you qualify, your court-appointed attorney will be appointed today before you leave. Or if you are requesting to represent yourself, then you'll have an opportunity to talk to one of the prosecutors about your case. And then if you are able to work out a plea bargaining agreement, then your case will be taken care of today before you leave. Okay, now do we have any questions? Now, make sure you fill out the paperwork. Now, there are 2 restrooms in the hallway. We have the men's restroom in front of County Court number 3. And on the opposite side of the hall, we have the women's restroom in front of the 172nd District Court. You'll be allowed to go out into the hallway to use the restroom. Please do not, once you use the restroom, please come back into the courtroom. Please do not leave the courthouse. If you leave the courthouse and your name is called, and you do not answer when your name is called, your bond will be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. You will be arrested, placed in a county jail. You have to bond out of jail, and once you bond out of jail, you'll be given another court date, and guess what? We have to go through this all over again. And so, to expedite our time, make sure that you be mindful of the things that I just told you. Now, at this time, the court is going to be in recess. And since the court is in recess, we're gonna, you need to conduct yourself accordingly, and then we're gonna put you in the line so we can pick up the paperwork from you. And do we have any questions before we go? Yeah,
You could, we could put an intern.
yeah, we're gonna get an interpreter for him. He needs an interpreter, yes.
You don't mind, I got five, attorney, but he represented me on ability too. I just got him Friday, he was, guess he had something to do or whatever, so do I.
You already hired an attorney? So you're gonna place your initials on the second line. And then the name of the attorney on the line to the right of that second line. And that's the only document you have to fill out, that first document. Okay? Anybody else have a question?
You said, how did you leave him to the program still?
Which one? Oh, yeah, we have some folks here from Spindletop. Okay, they're here.
Yeah,
They'll come out and talk to you about the program that they have, okay? Do they have that did they put that little form,
no, I don't think so, because they weren't supposed to be here today.
well, they were supposed to be here,
Well, supposed to, but they only,
they didn't bring them? That's what you're saying?
I don't know. I might have some.
Cause I think even when they don't come, we just fill them out.
You said they had another one,
Yeah.
for spending time for.
Who needs one?
He needs one.
Anyone else?
Anybody else need anything in the form? Okay, now what were you saying?
They had another one, not just for spending time, but
Yeah.
for.
The CIC program? I mean,
You named about three.
yeah, I'm talking about the CSI program, the one with the community safety initiative, the one with
That's a
the,
job.
it is, it's Spindletop, all of it is under Spindletop, under the, CIC program. I mean, the CSI program, you have Spindletop is under there, and part of Spindletop, they have the ATAR program. And the, Ozark program, both of those are, ATAR, those are drug and recovery program. And then we have the job training program. CICE.
That's awesome.
That's also under our,
If you're done with your clipboard, you can bring it up to me.
are you interested in like the job program or? Okay, we'll give you a form for the job too. Okay,
you go in for him? Yes.
she has.
There's been dismissed on yours no more.
Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 26 CCCR 1524, case of style of the state of Texas versus Diego Armando Balderas Rowe. Would you please come forward? Diego Armando Balderas Rowe.
Yes,
Is that correct?
yeah,
Okay. Okay. How are you doing?
I'm good.
Okay. Now, you speak Spanish, a little bit of English, and we have our interpreter, our translator, Ms. Jennifer Raji. Ms. Raji, how are you doing?
Good, Judge, how are you?
I'm doing fine, thanks. Ask Ms. Raji, would you please raise your right hand? Do you swear and interpret Spanish to English and English to Spanish to help you God?
Yes, Judge.
Okay, you may put your hand down. Ask Diego. The full name is the full name Diego Armando Balderas Rowe.
Ese es su nombre completo. Así, yes, Judge.
Okay. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, Judge.
Okay, you may put your hand down. Come and stop.
Muy bien.
Yeah.
Very good.
Good, okay, good. Okay, now, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, Judge.
Is this your signature on the line that's titled Defendant?
Ese es su firma ahí. Sí. Yes, Judge.
And are these your initials on the line stating you'd like to hire your own attorney?
Y ese es su definición. No estoy diciendo que quieres agarrar su propio abogado. Sí. Yes, Judge.
Now, before you signed and initialed this document, did Ms. Haraji go over this document with you in Spanish?
¿Se lo quieren? Así. Yes,
And,
Judge.
and did you understand everything that she went over?
Y usted, todo. Yes, Judge.
And is everything in this document true and correct to the best of your knowledge?
Todo ese documento es de verdad. Así. Yes, Judge.
Okay? So your case will be reset to give you time to hire your own attorney. You're gonna get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day. Okay? Stand in front of the court coordinator.
Have a good day.
Mario Lemus Hernandez. Tell him put his hat on the table.
Voilà. Voilà.
Okay. Ask Mr. Hernandez if his full name Mario Lemus Hernandez. Okay. Ask, raise his right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, Judge.
Okay. Tell him he may put his hand down. Come on, stop. Yeah,
Good.
that's good. Now, Mr. Hernandez, showing you a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, Judge.
Is this your signature on the line that's titled Defendant?
Yes, es su firma. Yes, Judge.
Are these your initials on the line that state you would like to hire your own attorney?
Yes, Judge.
Before you sign and initial this document, did Ms. Haraji go over this document with you in Spanish?
Yes, Judge.
And did you understand everything that she went over?
Yes, Judge.
Okay. And tell him his case will be reset to give him time to hire his attorney. Our court coordinator is gonna reset your case. Once the case is reset, you're free to go and you have a blessed day. And you're free to. All right, thank you. And you're free to go as well, Mr.
Thank
Roger.
you.
You have a blessed day. You're welcome. Okay, Mr. Hines. Let's see. Your full name is Rodney Daniel Hines?
Yes.
Mr. Hines, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Hines, you may put your hand down. How are you doing, Mr. Hines? I'm doing fine, thanks for asking, Mr. Hines. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yeah.
Is this your signature on the line as titled defendant?
Yes, sir.
And are these your initials on the line stating that you've hired Marvin Lewis as your attorney? Now, before you signed and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Sir.
Okay, Mr. Hines, your case will be reset. You need to, when you talk to Mr. Lewis, you need to tell him he needs to give this court a letter of representation. When you tell him that, he'll know what you're talking about.
Yes, sir.
The letter of representation is just a letter informing the court that he has been hired by you to represent you in this case. All right? So our court administrator is going to reset your case. Once you reset your case, you're free to go and you have a blessed day. Yeah, that other form. Did he? Thank you. Sarah Lynn Lewis. Hey, Miss Lewis, I have before me, well, first of all, Miss Lewis, would you please raise your right hand? Miss Lewis, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Miss Lewis, you may put your hand down. She needs, yeah, why don't you get us some tissue?
Okay.
Okay. Okay, Miss Lewis, your full name is Sarah Lynn Lewis, is that correct? How are you doing, Miss Lewis?
I've been better.
Okay, I'm sure you've been worse too. Now, Miss Lewis, I see here I have two documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line as titled defendant?
Yes.
Or are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
Yes.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes.
And is this your signature on the line as titled defendant?
Mhm.
Ms. Lewis, before you signed and initial these documents? Did you read the documents? Did you understand what you read?
Yeah.
Is everything in these documents true and correct to the best of your knowledge? Okay, now, Ms. Lewis, I understand that you have talked to the prosecutor in this case, is that correct?
Mhm.
And you requested to talk to the court. Okay? And, okay, what is your question? Oh,
I'm being charged, with the DWI when I was not arrested, I was not pulled over, I was not in my vehicle. I was arrested in the yard of my boyfriend, I was asked to sit in a police car, I was not put into that until I was brought to the jail. I don't understand how I'm being charged. I understand that after I was taken to the jail, they were trying to give me medical treatment, which I refused. I was then taken to the medical center. My blood was taken. Therefore, they had, blood proof that I was above legal limits.
okay, now, Ms.
So there is that.
Okay. Now, let me ask you, now, Ms. Lewis, first of all, as a judge, I can't give you any legal advice, okay? And based on what you're saying, obviously, the district attorney's office, they're the ones who prepared a charging instrument. The charging instrument is what we know, or what is commonly referred to in a misdemeanor case as an information. Now, as to what the law enforcement officer decided to charge with, I have no idea or any information on that. Okay, so if you would like to consult, now you are representing yourself. You can, as I mentioned to you earlier, the last paragraph says that if you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. That is, you can see if you qualify for a court-appointed attorney. Or if you do not qualify for a court-appointed attorney, you may want to, or you still have the option to hire your own attorney. Okay, but as to the question that you're asking, I can't answer that.
Okay, so the only options are to hire an attorney. Is that what you're telling me?
No, I told you you had three options. One option is to hire an attorney. Another option is to see if you qualify for a court-appointed attorney. And the third option is to waive your right to an attorney to represent yourself. Those three options.
Okay, in order to proceed without being charged with a class A felony, what am I being charged with then?
Oh, let's see, this is, hold on a minute. Oh, this should be a Class A misdemeanor.
Yes, sir. Point one.
Driving while intoxicated with an alcohol concentration level of 0.15 or more. That's classified as a Class A misdemeanor.
So unless I have an attorney, that is what I'm being charged with.
You're charged with that whether or not you have an attorney.
Okay.
Having an attorney does not dictate how you're going to be charged, because I'm sure the charge occurred before you were either, well, you were arrested and then they had to fill out a police report, etc. And then it got to this point to where it went to the district attorney's office, and the district attorney's office reviewed and decide how they like to charge.
Okay, so how do I proceed?
Okay, what you mean by how do you proceed? Now, okay, first of all, we talked about your three options regarding your right to have an attorney. If you would like to continue to proceed pro se, or you would like to change your mind and ask for time to hire an attorney, or see if you qualify for court-appointed attorney. Now, if you proceed pro se, meaning that you're representing yourself, you're acting as your own attorney, then the state is going to make an appointment for you to have what is called discovery, as I mentioned to you earlier, where you can have access to the evidence. You can have access to it. They're not going to give you because the Article 39.14 does not allow them to or require them to give you discovery. You can have access to it.
I can't be given proof of what I'm being charged.
You can have access to you. If you represent yourself, it would be a good idea to read the Texas Code of Criminal Procedure. And if you read the Texas Code of Criminal Procedure, Article 39.14, it talks about discovery, what the state can and can't is allowed to do regarding that discovery.
And if I hire an attorney, then they are able to.
They'll be given access, they'll be given the discovery. But I think even if you read the code, they're not allowed to give you discovery.
The attorney is allowed to have
Yes,
in order to represent me.
yes.
Yes.
Yes, I mean, that's how they wrote the code, the legislature did. Okay,
So I don't have any rights to proof of what the state is charging me, other than,
you read the code. I mean, you just have to see one thing about when you're pro se, you're held to the same standards as a licensed attorney because you're taking on that responsibility instead of hiring a licensed attorney or having one appointed to represent you.
okay, well, then, moving forward, I need to be represented, I guess, because if the state is not going to allow me evidence of what they're.
So you want to change your mind? I mean, you're going to make another choice?
Yes, sir.
Okay. Miss, okay, well, I'm going to give you this. He's going to hand you this document. And you can have a seat in that chair, and you can make your choice. And depending on what you choose, then we'll decide whether or not we need to provide you with, you know what? We're gonna just have a seat in that chair right there at the table, okay? And we're gonna give you a clipboard. The clipboard. You probably could get one out of the trade. Yes, sir. In the back. Thank you.
Lord Williams is going to see if he applies for a court appointed attorney.
Okay. Would you please come forward? 26 CC 1 5 2 2. Okay, Mr. Williams. Your full name is Jordan Rashawn Williams, Rysson Williams. Okay, Mr. Williams, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Williams, you may put your hand down. How are you doing, Mr. Williams? I'm doing fine, thanks for asking. Mr. Williams, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
Is this your signature on the line that's titled defendant?
yes,
And are these your initials on the line that state you would like to apply for a court-appointed attorney?
yes,
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
yes,
And is this your signature on page 2 of this document?
yes,
Now, Mr. Williams, before you sign and initial these documents, did you read the documents?
I did.
Did you understand what you read?
Yes,
And is everything in these documents true and correct to the best of your knowledge?
yes,
Now, Mr. Williams, I was looking at this application. And I'm going to, let's see, I have some non-public information that I will need to discuss with you. I'll just put this on mute. Yeah, I don't think you meet the eligibility requirements for the appointment of a court-appointed attorney.
yes,
Now, you can, at this point, you still have an option. You can have your case reset to hire your attorney, or you can represent yourself. Those are the two options that you have.
I go represent myself, so,
You would like to represent yourself?
yes,
Okay. Now, also, okay, we already went over that. Now, you've talked to the state, is that correct?
yes,
And Mr. Masradian, did he talk to you?
Yes, Your Honor. If it's all the same, I would say hiring an attorney for the point of just applying for pretrial diversion might not be too expensive if you're worried about finances. Just saying.
that's what I'm also, cause I'm looking at it as far as, me hiring an attorney just to get put in the program. I'm gonna spend more money doing that rather than just getting in the veterans program.
Oh, so you want to get into the veterans program?
I wanna get into the other one, but I wouldn't spend money on the veterans, but I'm also taking care of my mother, so.
Okay, so you're saying, okay, so I mean, so. Yeah,
I just don't know like the price of how much that's gonna cost just to get.
you can talk to some lawyers.
I mean, I'll try that, yes,
I mean, you just don't know. You can talk to some.
I'll try that first.
Okay, he's gonna have to make a change here and
So maybe more than that, and put your initials into that one. Mark that out.
Oh, so you want me to,
Wait.
no, he
that's what,
Oh, hold on.
he want to talk to him, and so you want to talk,
No.
when you want to hire, that means you want to talk. You got you have to,
oh, I thought it was the right one. Well, no.
He's hiring an attorney, right?
right.
It's the top one. Yeah, top one. Come on, Jordan.
I told you I wasn't, you confused.
Okay, just give me the paperwork back.
I'm still thinking.
I still need that other paperwork showing that he was denied, he didn't qualify.
Heck, I'm like,
Okay. Now, okay, so your case is gonna be reset.
Yes.
I'll give you opportunity to talk to some attorneys about your case. Okay, see if you could hire an attorney, okay? Our court coordinator is gonna reset your case. Once your case is reset, you'll be free to go. And you have a blessed day.
Thank you.
Yeah, okay. Sarah Lewis? Ms. Mosby, did you give those documents?
oh, we're applying for court appointment? Change this.
I think I'm on
Oh. When I gave you the rules of program. Oh, no, income.
Mr. Maserati, I think he's trying.
You don't have any income?
I was just like, I was 17 on this, as of right now. I've been working for this company. I can't work as a nurse right now because I am pretty sick.
So no.
I have 2 more checks coming from Terrence.
Judge. She said he's receiving severance pay.
That goes with Hey, Ms. Lewis. Please raise your right hand. Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Ms. Lewis, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? Are these your initials on the line that's titled defendant?
Yeah.
And is this your signature on the line that is titled defendant? Now, your initials are on a line that state you like to apply for a court-appointed attorney. Is that correct? I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature? Now, Ms. Lewis, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Lewis, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please stand in front of our court administrators. Jacoby Garnett Garrett.
Yes, Your Honor, there's an accompanying felony 26 DCCR 0501. These are the third. Court date is August the 18th.
Yeah, it's on the docket. This court date is on the docket. Felony court date. Okay. Now, Mr. Garrett, your full name is Jacoby Garnett Garrett.
Yes.
Mr. Garrett, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
That door is locked, ma'am. It's open. Okay. Would you please raise your, okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you may put your hand down. How are you doing, Mr. Garrett? Okay, so you had some worse ones too.
Well.
Well, I mean, and you keep giving, you know, in life we have ups and downs, trials and tribulations, so we have some good days, we have some bad days. It's just, it's like the weather. Sometimes we have sunshine, sometimes we have rain. Okay? We need the rain, right? No rain, we don't have no grass growing. No cows eat the grass. We can't eat the cow. So yeah, but we always have, but guess what? Rainy days don't last forever. Okay? And so this too shall pass.
Right, sir.
That's right. It will. Just be patient. It'll pass. Okay. A lot of times we kind of we put a lot of worry, we worry about things that we have no control over. One of the things we don't have control, we can't control the future. We don't even know what lies in the future. So a lot of times we start worrying about the future, but why are we worrying about things we don't have control over? Okay, just take it one day at a time, and this too shall pass. Now, Mr. Garrett, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you would like to waive your right to attorney and represent yourself?
Yes.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Sir.
Now, Mr. Garrett, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Sir.
Okay, Mr. Garrett. I read your answers. And based on your answers and the statement that the prosecutor made concerning you having a felony, which is set for August 18th of 2026, this case will be reset to that date. One reason is because this offense occurred at the same time that your DWI third occurred. So they are, we say they are the same criminal episode. That just simply means that they happen at the same time.
Correct.
During the same events. Okay, so this case will be reset with your felony case. Now, on that day, you need to come to this court. Both of them are gonna be set at 9 o'clock. So you come to this court first, check in with the bailiff, and then go to the felony court. And once you finish in felony court, then you come back here and let us know what happened. Okay? So you just have to remember to come to this court, just check in and then go take care of your business down there. And once you finish down there, you come back and let us know.
Then we come back, like, for the day.
What you mean that, well, if they don't let you come back, that means that when you talking about once you finish,
Yeah, like,
you talking about like, if they put you in jail, well, you'll be in a holding cell. The holding cell is right here. Okay, so our bailiff will be aware and we'll ask you to come out. She'll come and get you. Okay? All right, but I would imagine that he just probably set for initial appearance.
That's correct.
for what?
Felony court. They're gonna go down there and will tell you that if you haven't hired an attorney, they're gonna do some of the same.
What?
Okay. So just stay in contact with your court appointed attorney. Your court appointed attorney gonna advise you what to
I've really
do.
been trying to, he doesn't answer the phone.
You just have to keep on trying.
Every time he do answer the phone, like the last time he said he was gonna call me back and never did, and when I called him again, felt like his phone was on lock or something.
Okay, well, you just need to continue to call him and set up an appointment.
Set up an appointment.
Yeah,
Okay.
so you can sit down and talk to him. Okay, that's all you need to do. All right. So you get your reset. Once you get your reset, you're free to go. And you have a blessed day. Okay.
They had both of y'all sit on yesterday, and then they reset my other one and to August 18th, and I guess
Right.
they changed this one to the
Right.
28th,
You see, a lot of times,
but it was originally on the 27th.
yeah, what they do down there, we don't know.
Oh, okay.
So it's like the left hand don't know what the right hand is doing. And so once you come in and tell us, normally, now, this is set on the 18th, right?
Correct.
So if they reset that case, be mindful that we don't know.
Y'all not gonna like this time.
Right.
Yeah.
So you're gonna you have to come and tell us. That's why I tell you, come back.
In the day.
Right, and tell us what happened on the case. Okay? All right, just be patient, okay?
Yes, sir.
All right. Hmm? Mr. DeStacy Warrens? Mr.
Yes, sir. Yes,
Okay,
sir.
okay, how are you doing?
I'm doing okay.
Okay, now, the question is, why weren't you in court today?
Cause I'm at my first day orientation for my job.
Okay,
I couldn't miss it. Cause if I missed it, they not gonna be able to reset me for another date.
okay, well, we're gonna give you a date for you to come into court because you need to sign this paperwork unless you have already hired an attorney.
No, sir.
Okay, now you sat through, the arraignment. And so what's the court date? Well, yeah, we can reset you to next week. Come in and sign the paperwork.
Ah, next week. You don't think you can do me like 3 weeks from now? A month from now?
No, we can't do that because actually the day was supposed to be the day for you to be here.
Yes, sir.
Now, if you hire an attorney before now in your next court date, your attorney is going to get your case reset. So which means that you won't have to come into court.
Well, just let me know today so I can try to request the day to be off.
Okay, what's the day? Okay, it's August the 4th.
August 4th. Damn.
Yeah, now, sir, we're in court. You shouldn't be using any foul language.
I got you.
Okay,
August 4th, this next Tuesday.
is it Tuesday? Yes,
Yeah, next Tuesday. At what time?
9 a.m.
Got you.
Okay.
Yes, sir.
Okay, so it's August 4th at 9 a.m. County Court at Law Number 2, Jefferson County, Texas, Judge Terrence Holmes presiding. Now, you're free to go stay in contact with your bondsman.
Appreciate it.
All right. Okay. Who else we have? Jefferson County Court at Law number 2 is back in session. The court is in session with its initial appearance or arraignment docket. First case is cause number 26CCCR 0944. Case is style of state of Texas. First is Latrina K. Burton. Latrina K. Burton was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Latrina K. Burton at the courthouse door. Latrina K. Burton did not answer. Latrina K. Burton has not appeared in court since the court has been in session. The time now is 11:48 a.m. on today's date of July 28, 2026. Miss Bailiff, could you please call the name of Latrina K. Burton at the courthouse door?
Latrina K. Burton. Latrina K. Burton. No response, Your Honor.
Okay, Latrina K. Burton name was just called again at the courthouse door. Latrina K. Burton did not answer. A reasonable time has passed to give Ms. Burton an opportunity to appear in court. She has not appeared in court. State, do you have a motion? That motion will be granted. Latrina K. Burton bond will be forfeited and warrant should be issued for her arrest in cause number 26CCCR 0944. Next case is cause number 26CCCR 1042. Case of style of state of Texas versus Isaiah J. Calhoun. Isaiah J. Calhoun was scheduled to be in court this morning at 9 a.m. At about 9 a.m., Isaiah J. Calhoun name was called at the courthouse door by the court's bailiff. He did not answer. He has not appeared in court since the court has been in session. The time now is 11:44 a.m. on today's date. Ms. Bailiff, would you please call the name of Isaiah J. Calhoun? And today's date is 7/28/2026. Okay, Isaiah J. Calhoun's name was just called again at the courthouse door. Isaiah J. Calhoun did not answer. A reasonable time has passed to give Mr. Calhoun an opportunity to appear in court. He is not appearing in court. State, do you have a motion? That motion will be granted. Warrant should be issued for the arrest of Isaiah J. Calhoun in cause number 26CCCR 1042. Next case is cause number M323-104. Case is style of the state of Texas versus Jacob Garza. Jacob Garza was scheduled to be in court this morning at 9 a.m. At about 9 a.m., Jacob Garza's name was called at the courthouse door. Jacob Garza did not answer. He has not appeared in court since the court has been in session. The time now is 11:45 a.m. on today's date, July 28, 2026. Ms. Bailiff, would you please call the name of Jacob Garza at the courthouse door?
Jacob Garza. Jacob Garza. No response, Your Honor.
Okay, Jacob Garza's name was just called again at the courthouse door. Jacob Garza did not answer. Reasonable time has passed to give Mr. Garza an opportunity to report. He has not appeared in court. State, do you have a motion? That motion will be granted. Jacob Garza's bond will be forfeited and the warrant should be issued for his arrest in cause number M323-104. Next case is cause number 26CCCR 0144. Case is style of the state of Texas versus Joshua Alexander Holyfield. Joshua Alexander Holyfield was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Joshua Alexander Holyfield at the courthouse door. He did not answer. He has not appeared in court since the court has been in session. The time now is 11:46 a.m. Ms. Bailey, would you please call the name of Joshua Alexander Holyfield at the courthouse door? Joshua Alexander Holyfield.
Joshua Alexander Holyfield. Joshua Alexander Holyfield. No response, Your Honor.
Okay, Joshua Alexander Holyfield's name was just called again at the courthouse door. Joshua Alexander Holyfield did not answer. Reasonable time has passed to give Mr. Holyfield an opportunity to appear in court. He's not appearing in court. State, do you have a motion? That motion will be granted. Joshua Alexander Holyfield's bond will be forfeited and a warrant should be issued for his arrest in cause number 26CCCR 0144. Next case, or the next three cases, or cause numbers 26CCCR 0654, cause number 26CCCR 0738, and cause number 26CCCR 0739. All three cases are styled in the state of Texas versus Aaron Neal. Aaron Neal was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Aaron Neal at the courthouse door. Aaron Neal did not answer. Aaron Neal has not appeared in court since the court has been in session. The time now is 11:48 a.m. on today's date of July 28, 2026. Ms. Bailiff, would you please call the name of Aaron Neal at the courthouse door?
Aaron Neal. No response, Your Honor.
Okay, Aaron Neal's name was just called again at the courthouse door. Aaron Neal did not answer. Aaron Neal has not appeared in court since the court has been in session. A reasonable time has passed to give Mr. Neal an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
They moved the bond forfeiture, Your Honor.
Okay. Aaron Neal's bond will be forfeited and a warrant should be issued for his arrest and cause numbers 26CCCR 0654, cause number 26CCCR 0738, and cause number 26CCCR 0739. Next case is cause number 26CCCR 0970. Case is styled in the state of Texas versus Miracle Simmons. Miracle Simmons was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Miracle Simmons at the courthouse door. Miracle Simmons did not answer. A reasonable time has passed to give Miracle Simmons an opportunity to appear in court yet. Miracle Simmons has not appeared in court. The time now is 11:49 a.m. on today's date of July 28 of 2026. Ms. Bailiff, would you please call the name of Miracle Simmons at the courthouse door?
Miracle Simmons. No response, Your Honor.
Okay, Miracle Simmons' name was just called again at the courthouse door. Miracle Simmons did not answer. A reasonable time has passed to give Miracle Simmons an opportunity to appear in court. Miracle Simmons has not appeared in court. State, do you have a motion?
They moved the bond forfeiture, Your Honor.
That motion will be granted. The Miracle Simmons bond will be forfeited and a warrant shall be issued for the arrest of a Miracle Simmons. And this will conclude the calling of the court's Raymond docket, or the initial appearance docket on today's date, July 28, 2026. And County Court at Law Number 2 of Jefferson County, Texas, Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Court will be in recess until we resume with our trial at 1:30 a.m. Prosecutors, you are excused.
Thank you, Your Honor.